Missing just one accommodation request from a pregnant employee can cost your business thousands or more. Here's what you absolutely must know. First, the Pregnancy Discrimination Act treats pregnancy and related conditions just like any other protected class under Title VII, like race, religion, national origin, and more. That means if you accommodate other medical issues, you have to accommodate pregnancy too. Second, the Pregnant Workers Fairness Act, or the PWFA, requires employers with 15 or more employees to provide reasonable accommodations for known pregnancy-related limitations, unless doing so poses an undue hardship, which is just the legal way of saying this is more than my business can manage. If all of that sounds familiar, it's because it's similar to what you already have to do under the ADA. That means you must accommodate pregnancy too. Under the PWFA, your obligation isn't just avoiding discrimination, it's taking proactive steps to help your pregnant employees out. When a pregnant employee tells you they need help, say because of nausea, fatigue, or a lifting restriction, you have to start the interactive process just like you would under ADA regulations. Don't wait. Offer possible reasonable accommodations such as lighter duties or no heavy lifting, more frequent restroom and water breaks, permission to sit if her job requires standing or vice versa, flexible schedule for doctor's visits, remote work, uniform adjustments where possible. You get the idea. The law even recognizes that certain types of accommodations are almost always going to be reasonable in most cases. You do not have to grant exactly what they ask for, but you must offer an effective alternative. If leave is requested, but another accommodation would work without undue hardship to your business, you cannot force the employee onto leave. And remember, you have to document each step of the process. What was requested? What was offered? Any undue hardship analysis that you guys are thinking of. If you accommodate other medical conditions like in ADA-covered cases, you must provide equivalent support for pregnancy. That is, don't treat pregnant employees less favorably or any differently than you would somebody else. There's two essential federal laws that require lactation support. So, the Providing Urgent Maternal Protections for Nursing Mothers Act, called the PUMP Act, obligates nearly all employers of any size to provide reasonable break time and a private, non-bathroom space for pumping up to 1 year postpartum, with some limited undue hardship exceptions for businesses with fewer than 50 employees. Under the PWFA, the right to pumping breaks in space is explicitly part of pregnancy accommodations. That space has to be functional. It's got to be shielded from view, free from intrusion, and used only for pumping. Break times, with time for equipment setup, counts as time worked if work tasks are still being performed during that break. EEOC guidance confirms that the PWFA covers pregnancy-related medical care, including fertility treatments, miscarriages, abortions, and postpartum conditions. Whether abortions are covered continues to be the subject of court battles, and that can change. That all means that time off or duty adjustments have to be required. Pregnancy discrimination is sex discrimination. Under federal law, no one has to disclose their pregnancy, but once an accommodation is requested, you're legally required to respond. Right now, here's what you need to do. Train managers. Empower them to recognize accommodation requests. Don't just wait until an employee brings in some paperwork. Document everything. Requests, conversations, accommodations, and any undue hardship rationale. You gotta prep a lactation space. Something clean, private, non-bathroom, with a chair, outlets, and shielded from view. Review your policies. Make sure you have uniform breakdowns, leave policies, light duty protocols, break time, all aligned with the PDA, PWFA, and PUMP Act. Consult counsel early, especially before denying any requests, denying any leaves, or denying anything else. You can't always unring those bells. Bottom line, these are not optional niceties, they're legal requirements. When an employee says, "I'm pregnant and need help," you're not allowed to say no. You must respond, accommodate, document, and support them. By doing so, you're saving your bottom line and demonstrate that your business supports your employees at a time when they really need you. Thanks for watching.